Hi, today's topic is how to protect your case for immigration court. Now, my name is John Ting. I practice immigration law in the United States, physically with a physical office in Houston, Texas, here to solve your immigration problem or maybe prevent the problem from happening in the first place, folks. If you got a case in immigration court, you want to get your case dismissed, terminated. It's very, very important to do that because even if you have an asylum case, USCIS just came out with some specific policy on guidelines on how to get your case dismissed so that USCIS can process the case. And the reason why people were concerned about it is because, okay, well, if I dismiss my case, will I get my work permit? Will I still be able to use work permit? And USCIS has stated yes, the case will continue. Even if you get your court case dismissed and you file for asylum, it will still be in the system so you can continue working. Okay, that's what we've been told. That was official guidance on paper online, USCIS website about at least 2 months ago, and it was happening anyway for the past year or so, but all of us lawyers are like attorneys like, "Okay, that's great, but can you put it on paper, a policy?" So it gave everyone more, assurance, right? Alright, so the first thing to do is contact this is assuming you don't have a lawyer or you can't afford a lawyer, right? Contact Google search first your local office of chief counsel, right? Let's say you live in like Austin. Austin does not have an immigration court, right? But San Antonio does. So I believe people who live in Austin, Texas, their case would be in San Antonio. Could be wrong, but that gave you an idea. You live in Waco, Texas, you get those Magnolia Bakery cupcakes. There is no court in immigration court in Waco, Texas. So those cases, the people who live there would be in Dallas immigration court. So why am I saying this? Because I could just say step one, request email Department of Homeland Security, but really you need to know which office to contact. There's not just one main email. Thank God, honestly, because there'd be so many. There's already a lot of inquiries, but they have it by city essentially, by major city. So keep that in mind, okay, when you search, because you might not find one in your local area like Waco or Austin. That's step number one. And then you might ask, well, how long will it take for them to get back to me? They're not fast, okay? They're only quicker when you have maybe a hearing date like next week or like tomorrow, and they finally get back to you. And it's not a guarantee that they would contact you back. So please do not assume, well, even if Department of Homeland Security gets back to you and they don't mention anything about like, let's say they do say, yeah, we're going to agree to dismiss your case, but they don't mention anything about not showing up, which I wouldn't trust them in that respect. You still need to show up to court. The only situation you would not need to show up to court is if you see a physical piece of paper, okay? I got some court orders laying around somewhere. If you got a physical piece of paper, or if you print it out, right? I guess that has a court order dismissing or order terminating case. That is the only time that you can feel reassured to not attend court, to not appear in person. Otherwise, if you have not received that piece of paper, order dismissing the case or terminating the case, you still need to appear. And here's why. Even if Department of Homeland Security attorney says, you're good to go, boss, or I agree to it, doesn't mean much. I mean, it's a good answer. It's great. That's really the cover step number one. But if you don't show up to court, even if Department of Homeland Security agreed to the joint motion, the judge's job, they would normally do is find you removed, what we call in absentia. You didn't show up. You were absent. So we don't want that situation for you because you could have done everything you could have or done, and then you're like, oh shoot, I was supposed to show up. Okay. And here's another tip. If you call into the court and you speak to a clerk, look, the clerks are busy, busy. So if you give them your A number and you're like, do I need to show up because I got this like agreement from Department of Homeland Security? Look, a clerk is not there to give you legal advice. Okay. But even if on accident the clerk says, oh, yeah, 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 you got an agreement from DHS, the TA, you're good to go. TA, we call trial attorney for the government. Oh, you're good. But you're like, "What?" And then you're thinking, well, your first thought is like, "Oh, good. I don't have to show up." No, you still need to show up. The person did not actually say you don't have to show up. But even if they did, here's the other way that you need to support to make sure is because you, number one, I don't think unless there's a lot of lead time, like many weeks in advance, they would send you something to say in the mail, say canceled or case terminated, right? But here's the best way. Let me find this website for you. EOIR, case status or something, or automated case, it'll pop up the link. And that just covers step number 1, but with many tips. Here's step number 2. You need to file the motion, the formal motion, but you might not know how to do all that, right? So that's what a lawyer is for, to help you with that part. And let's say in the situation I'm just sharing other scenarios. Let's say you're in court and the judge like, okay, we're gonna order dismiss, and you're like, I didn't have to file anything. Filing motion is helpful because especially if you're like several months away from the actual hearing, you can maybe get a judge to make a decision on it before you even have to show up to court. Some of y'all have a case in like California, but you live in Kansas. It's because you moved, right? So to prevent you having to fly over there or drive all the way there to California or another state, you might as well try to file that motion if you have time. But if you don't file that formal motion, or if you're not in court to ask for it, that to ask meaning like let the judge know, okay, I'm here to dismiss my case because government attorney agreed to dismiss it, and I have a pending whatever application, I-130, for example. Look, I'm not trying to tell you how to practice law, but I want to share some tips in case you don't have the budget for it, right? It's very important because a lot of people get stuck in a court case, and come to realize after all the people been talking to, the case could have got dismissed a long time ago. And you've had to spend money and time practically just to show up to court. And the judge is not going to tell you, the government lawyer is not going to tell you step by step what to do. Right. Even for me, I'm not supposed to tell you step by step what to do. That's just the general steps. All right. And even if the judge gives you that order and you have a pending case, guess what? USCIS and the court, EOIR, Executive Office of Immigration Review, do not talk to each other. Okay. So if you have a pending application with USCIS, you need to notify them. Or maybe it's not pending anymore. Maybe it's been admin closed. So USCIS needs to know about it. That's where lawyers come in again. Private attorneys like my law firm. All right. So hopefully that gives you an idea.